Fuck. Fuck this shit.
Well, folks, I found an article today in the Connecticut and ctpost.com. Bridgeport, the state Supreme Court Monday threw out the conviction of a man found guilty of sexually assaulting a severely handicapped woman. In a 4-3 decision, the High Court ruled that despite evidence, the 26-year-old woman cannot speak and has little bodily movement. There was no evidence she could not communicate her refusal to have sex with the defendant, Richard Fortin Jr. As a result of the ruling, Fortin goes free and cannot be tried for the case again. Now, let me see if I can help people understand this concept. Essentially, because this young lady was severely handicapped, mentally and physically, she could not give her consent to have sex. And the judge ruled, well, that means she couldn't say that she didn't want sex. I'm sorry, I was always under the impression, because Mama Dumock raised me right, excuse me, that lack of consent is lack of consent. If somebody doesn't have the ability to give their consent, the answer is no. How hard is that to understand? Now, I don't even understand why somebody would try to have sex with somebody who is mentally and physically handicapped, except that they have some really serious psychological issues. And I'm hoping that this guy gets some serious counseling. But let's be honest here. That piece of garbage deserves to be in jail. He raped someone who could not defend herself, could not protect herself. He took advantage of a handicapped person, and now he's getting away with it scot-free. This is one of those times where I say, you know what? I am hoping that karma catches up with this guy, because he seriously deserves an ass fucking from a 14-inch purple dildo of doom sported by a 7-foot-tall goddess. Now, let me read more of this article, because it gets much more infuriating as it goes along. Apparently, these judges don't have daughters. And if they do, more likely than not, they're probably dancing around the stripper pole. That's how stupid these judges are. Allow me to continue. In January 2008, a 28-year Fortin was convicted by a jury here of attempted second-degree and fourth-degree sexual assault and sentenced to 6 years in prison for sexually assaulting the severely handicapped woman in the Success Village housing complex in 2005. The woman, now 29, who in court only went by her initials LK, has severe cerebral palsy and cannot verbally communicate. She is also physically restricted, and that she is also so physically restricted that she is able to make motions only with her right index finger. It gets better. In order for the woman to testify during the trial, a small video camera was placed over her and a tray affixed to her chair. On the tray, the prosecutor placed a board printed with the letters of the alphabet along with the words yes and no on top. After each question, the woman's left hand would push her right hand, index finger sticking out, across the board to either spell out a word or answer yes or no. It was exhaustive. This is what the poor woman had to go through during this trial, mind you. However, the defense argued that there was evidence that the woman could communicate by kicking, biting, screaming, and gesturing. They presented testimony at trial from a home health aide who said the woman could kick and groan if she didn't get the food she wanted. Again, The woman is mentally handicapped. Let me continue, because this is getting ridiculous. The state appellate court later ruled she is not physically helpless under the state law in which a jury convicted Fortin. The state then took an appeal to the Supreme Court. We are persuaded that the victim was either unconscious. No! That the victim was either unconscious or so uncommunicative that she was physically incapable of manifesting to the defendant her lack of consent to sexual intercourse at the time of the alleged sexual assault. The High Court ruled Monday. The 3 dissenting judges accused the majority of acting as a 13th juror in the case and substituting their opinion for that of the jury. Now, I'm going to post a link. I know I read you the whole article, but I'm going to post a link down below, and you can read it and get as outraged as I am. What the hell are these judges thinking? Really? Really? That just because she was physically and mentally incapable of giving her consent or withdrawing her consent, that means consent? Really? You don't have daughters, do you? You don't have sisters. You don't have mothers. You don't have cousins. You don't have female members of your family, do you, judges? Apparently, you have no capacity of understanding what consent means. Consent is consent. It means yes, I want sex, or no, I don't want sex. And the default position for any gentleman, any man in a relationship with a woman, the default position is, unless she specifically gives her consent, the answer is no. Are you people really that fucking stupid? How the hell did you get to be Supreme Court judges in the state of Connecticut? Who did you sleep with to get the job? Because evidently you didn't get there based on your qualifications. It's a young woman who is incapable of giving her consent. She does not understand. She can't give her consent. So the default position is not, sure, go right ahead. It's no. The default position is no, especially if you're dealing with somebody who is physically and mentally handicapped. The default position for sexual consent is no, unless specifically and explicitly given otherwise. And if you don't understand that, I pity your daughters, because apparently apparently any woman in your family is at risk because of your own stupidity, because you don't seem to understand. No means no. And no answer means no. This is Dumock the Artist signing off. Slanchini Fulcher. Have a nice day.